founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the League of Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
The firm invests in its team and emphasizes professional development. We are keen to share our knowledge and publish our articles on our website. And we also give back with our corporate social responsibility activities. We cultivate a passion for the law and enjoy what we do. This brings out the best in us for our clients today and tomorrow.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Ma Wing Kwai & Associates is a mid-sized law firm that was founded in 1985 by Dato' Ma Wing Kwai. Our able team today comprises of 22 lawyers and a support team of 19. Dato' Ma is a consultant with the firm following his retirement from the Court of Appeal bench in 2015. The firm continues its tradition today of working primarily with small and medium enterprises, family businesses, and individuals. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were broadcasted live. But with the COVID-19 Movement Control Order, or MCO, we have moved online in order to continue with our objective of sharing knowledge, encouraging networking for clients, potential clients, and in-house counsel. This is the 17th talk for our MWKA online series, which has been attended by some 3,644 attendees. Today, we are expecting about 115 individuals who have registered. Please visit our website at mawingkwai.com for more information, to read our articles, and to sign up for more upcoming talks. Before I continue, please be reminded that this talk does not constitute legal advice. In the event that you require specific legal advice to your matter, please contact us for a complimentary legal consultation. Details will be given at the end of this talk. Now moving on, let me introduce the first speaker of today, Carmen. Carmen is our associate in our dispute resolution and individuals and family department. She graduated from Cardiff University. She was called to the English bar in November 2018 and was subsequently admitted to the Malaysian bar in 2020. Our second speaker of today is Eric. Eric is also an associate in our dispute resolution, individuals and family department. He graduated from Australian National University and he was admitted to the Malaysian bar in 2018. Our speakers hope to complete today's talk by 11:45 and thereafter proceed to the Q&A session. If you have any questions, please post them up on Slido and our speakers will address them shortly. A link to Slido was given during registration, but I will leave this slide up for a few seconds for you to scan the QR code so that you can post your questions later. Now moving on to our top points. Today's online talk will cover what should you do when preparing to file for divorce and what should you consider when you're being served with a joint or single petition. Carmen will start our online talk today with an overview of the divorce under Law Reform Marriage and Divorce Act 1976 and joint petitions for divorce, while Eric, on the other hand, will address single petition for divorce and frequently asked questions. With that said, I will now invite Carmen to share her insights. Over to you, Carmen.
Thank you, Prisilla, for the warm introduction. Good morning, everyone. I would like to start the talk by giving an overview on divorce. Matrimonial matters concerning non-Muslims in Malaysia are governed by the Law Reform Marriage and Divorce Act 1976. Therefore, it applies to non-Muslims only. However, there are certain limited circumstances where persons who convert into Islam can still get divorced under the LRA 1976. So, who can apply for a divorce? Any persons who are married under the LRA 1976 can apply for a divorce. The LRA does not apply to any native of Sabah or Sarawak unless the person contracted his marriage under the Christian Marriage Ordinance and Church and Civil Marriage Ordinance. Next, there are two main methods to obtain a divorce in Malaysia. One is by filing a joint petition, whereby there's consent by both parties to divorce. Second method is via filing a single petition in court. A single petition is where there is no consent by both parties to divorce or no consent to certain terms of the divorce. I will now address the part about joint petition. So the process of filing a joint petition is as such. Once you have filed the joint petition, you would have to wait 1 to 2 months for a hearing. A date will be fixed and parties will require to be present before the judge in the High Court. This is for a hearing of the joint petition. During the hearing, if there's no further issues raised by parties or judge regarding the joint petition, the judge will immediately grant the order in terms, which means a decree nisi will immediately be granted. Decree nisi is an order by the court stating the date of which a marriage will end, unless a good reason not to grant a divorce is produced. Once the decree nisi is granted, the parties will have to wait for 3 months before the decree nisi will be made absolute. The 3 months waiting period is standard, but in exceptional circumstances, the court will fix a shorter time. A decree absolute is a court's final order officially ending a marriage and thereafter allowing parties to remarry. Moving on, there's also a requirement for parties to file a joint petition for divorce is that parties must be married for at least 2 years prior to filing for divorce. Of course, there are exceptions to the general rule. For this case, the exception of the 2-year requirement can be made on grounds where there is exceptional circumstances or hardship suffered by the petitioner or where one party has converted to Islam. Next, we will move on to the topic on domicile. The party that seeks for a divorce must be domiciled in Malaysia. To explain this, domicile is a person's place of residence or ordinary habitation, a house or home, the place where one has his permanent residence to which, if absent, he has the intention of returning. So I'll give some examples on intention of returning. If a person has migrated overseas and stayed there for a long time, or if the person has given up all their assets in Malaysia, he does not have the intention of returning to Malaysia. Under the common law, if both parties' place of domicile is different, the wife's domicile will follow the husband's domicile. In a case illustrated in the slide, where the wife is a Malaysian and the husband is a Singaporean, the wife's domicile will follow her husband's domicile. That being said, the domicile of the wife will be in Singapore and the divorce petition should be filed in Singapore. As explained earlier, a joint petition is where parties mutually agree to dissolve a marriage. This is done by the consent and agreement to all the terms of a divorce by both parties. The terms that are agreed by parties will include terms as such: the access to children, agreement on the maintenance payment of the child and spouse, and the division of assets. Both parties have to be specific about each of the terms to avoid any future disagreements or disputes. I will then discuss each of these terms separately. Firstly, we'll move on to access to children. If the couple have children, this term will be important in a joint petition. A joint petition must contain terms regarding the custody of the child, whether it's sole custody or both parents having the joint custody of the child. The terms must also include which parent has daily care and control of the child, the access period of the non-custodial parent, where custody is given to the other parent. An example for this is where B will have access to the child from 7 p.m. on Friday until 12 p.m. on Sunday. You must also be specific on the transport and location arrangements. This is shown in the second example, which provides B will pick up the child from A's house on Friday and send the child back to A's house on Sunday. If there's overnight arrangements, you will also have to specify when the child is allowed to stay overnight. You can also state the modes of communication with the child, such as in point 3 of the slide, the child shall be allowed to communicate with B via phone or video call at reasonable times. Can also include the arrangement on the child's birthdays, such as the child should spend his birthday with B and C on an alternate basis. The arrangements regarding religious holiday, whereby the child should spend the second day of Chinese New Year with either one of the parents, and also on school holidays, the child shall spend half of his or her school holidays with one of the parents. Moving on to maintenance payments. For this part, we will split it to spousal maintenance and also child maintenance. A joint petition will usually contain a term for the husband to pay maintenance to his wife unless his wife agrees that maintenance is not required. Parties can agree either to pay by way of one-off lump sum or monthly payments. An example will be, in point 1 of the slide, B will pay spousal maintenance of 1,000 ringgit to C by the 7th day of each month. So you have to be specific on the amount and also the due date to pay such an amount. Moving on, for child maintenance, it will usually be paid to the parent having custody, care, and control of the child. Child maintenance will include the child's living expenses, child's education fees, medical expenses, and also insurance premium. An example for child maintenance will be point 2 in the slide. B will pay 3,000 ringgit per month as child maintenance for C by the 7th day of each month, with an increase of 10% every year. The increasing percentage is to catch up with inflation, or for instance, when the child grows older, they will require more things. It is up to the parties to fix the percentage. If it's a one-off lump sum maintenance payments, the term can be as point 3 in the slide. B will pay C a lump sum of 500,000 ringgit within 30 days of the granting of the decree nisi. For division of assets, parties can agree on the division of matrimonial assets in any way that they see fit. Assets might include a matrimonial home, monies in bank accounts, shares, or car. Both parties must make sure to include all the assets that they wish to divide in a joint petition, as the court will only grant an order for division of assets when granting a decree of divorce. So for an example, parties can sell the matrimonial home at market value and the net proceeds will be divided equally between B and C after the deduction of redemption sum, legal fees, and also agent fees. You can also add another term which provides, if the matrimonial home is not sold within 6 months of the decree nisi at market value, the matrimonial home shall be sold at the value of the highest offer received, unless parties agree otherwise. This is to ensure that the matter is moving forward
If one party agrees to transfer half of his share of the property to another party instead of selling the matrimonial property, the terms can be as such. B is to transfer her half share of the property to C within 30 days from the decree 9 side. The expenses and costs for the transfer shall be borne by B. After looking at what is advisable to be included in the terms, let's look at some examples of the terms that are not recommended in the joint petition. So for access to children, parties are not advised to include such terms as in the slide, and I will read it out. Firstly, B shall have access to the child over the weekends, or B shall have access to the child during the child's school holidays, or the child is to spend time during Chinese New Year with B. These terms do not include the arrangement as mentioned earlier, which is the transport arrangements, time arrangements, and also location arrangements. We'll move on to the maintenance part. For terms regarding spousal maintenance and child maintenance, the examples that are not recommended will be, first, B will pay spousal maintenance of 1,000 ringgit to C, or B agrees to pay C an amount per month in the event C is dismissed from her employment until C finds a new job, or B will buy a car for C for C's use. These terms do not include the details as to when to pay, how much to pay, and certain specification of the subject matter. Next, we'll move on to the division of assets, whereby these terms are also not recommended because they do not have specific details provided in the terms. For the first two examples in the slide, there is no mention about the miscellaneous fees included and also the costs involved. For the third example, there is no mention as to when the transfer of the property should happen and the deadline involved. After considering all the terms in the joint petition, we'll move on to penal notice. It is recommended for parties to include a penal notice in the divorce order or decree 9 side. A penal notice is a warning endorsed on a court order, notifying the parties that he or she is liable to committal proceedings or to pay a fine for breach of such an order. Example of penal notice is shown in the slides, which reads, if you, the within name Albert, and with his IC number, neglect to obey this order by the time therein limited, you will be liable to process of execution for the purpose of compelling you to obey the same. The purpose of the penal notice is to ensure that the parties duly follow the terms in the joint petition. For an example, under the divorce order, B is supposed to transfer his share of the property to C within 60 days from the decree 9 side. B fails to do so within the stipulated time. C can then file committal proceedings against B to compel B to transfer his share of the property to C. If B fails to do so, B may be liable to a fine or imprisonment. Last but not least, a joint petition is generally quicker and cheaper than a single petition because the process are rather straightforward. As mentioned earlier, a hearing of a joint petition will usually be fixed 1 to 2 months after filing of the petition in the court. For a joint petition, it will usually take 1 hearing for the whole matter to be complete. With that said, I will pass the floor to my colleague, Eric, for the topic on single petition. Over to you, Eric.
Okay, thank you, Carmen. Right, good morning, everyone. Now is my turn to talk about single petitions. So a quick recap. So as Carmen mentioned earlier, to have a joint petition, you need agreement by parties to all the terms, or if both parties agree to the divorce. But what happens if one of the parties do not agree to a divorce? So one wants to get divorced, the other doesn't. Or what if your wife wants to have your kids over for Chinese New Year for 2 days, but you don't want, you only want 1 day? Or if one of the spouse wants 5,000 ringgit as maintenance and you don't want to give 5,000, you want to give 3,000 only. So what happens then? Then both of you, you will have to file a single petition for divorce because the terms of the divorce are not agreed by all parties. So again, let me give you a brief timeline of a single petition. Firstly, you have to register for marriage tribunal sessions at JPN, and this process will take 3 to 5 months to complete. Then you file your single petition after the JPN sessions, and this will take about 9 months from the filing of the single petition to the decision of the single petition. The 9 months will include the filing, the replies, the trial at court, and the hearing in court. So at the day of the decision of the single petition, the court, if is satisfied that the marriage has broken down, will grant a decree nisi immediately. And like a joint petition, the decree absolute will only be made, the decree will only be made absolute within 3 months unless the court fixes a shorter time for that. So let me get into further details on what do I mean by marriage tribunal. So before you can actually file a single petition, you have to go to the nearest JPN where you have to fill up a form and pay a 5 ringgit fee to apply to have sessions before the marriage tribunal. What happens after you register is that the JPN will send a letter to your spouse and yourself to tell you when is the sessions and when you have to attend. Usually the sessions will be 2 to 3 times, and between each session will be about 1 to 2 months. So the overall process will be about 3 to 5 months. So you need to consider that before you file a single petition, there's this prerequisite time that you have to satisfy. So it's not straight away you can go to court and file a single petition. However, there are ways that you can exempt yourself from attending these marriage tribunal sessions. And the ways are, if you look at the slide, is number 1, desertion, which means your spouse have left you with no intention of returning. You cannot contact him or her. Maybe he or she has left to another country. The second example is if your spouse is residing abroad in another country, is unlikely to enter Malaysia within 6 months after the date of petition. So for example, actually we did something like this for one of our clients, whereby the spouse is actually a foreign spouse living overseas. So what happened is we actually went to the immigration to check the records, the entry and exit records of this person, and then also put other evidence such as our client has attempted to contact him through messages or emails, but no response. Then because of that, we applied to court to exempt our client from attending marriage tribunal because the spouse is residing abroad and we think it's unlikely for him to come to Malaysia within 6 months. Okay, another reason is if your spouse is imprisoned for 5 years or more, your spouse is suffering from curable mental illness, or if there are other exceptional circumstances. And exceptional circumstances usually cover instances such as abuse, domestic violence, because then it is just unreasonable for them to ask you to attend marriage tribunal sessions. Okay, so that is the pre-filing of the single petition. So those are the requirements that you have to satisfy. So what happens after that? You want to file a single petition, what do you need to consider if you receive a single petition from your spouse? Okay, number 1, the breakdown of marriage is the sole ground of divorce. So nothing else, the court will just look at whether your marriage has broken down. So how do you prove the marriage has broken down? Again, there are a few examples of few grounds. Number 1, your spouse has committed adultery and you find it intolerable to live with your spouse. It seems quite straightforward. Secondly, if your spouse has behaved in a way such that you cannot reasonably be expected to live with him or her. So for example, if maybe your spouse is abusive, or if your spouse has been cold to you, doesn't talk to you for a very long time already, or if you find out that actually your spouse has a boyfriend or a girlfriend outside. And in fact, there are situations where I've seen that the spouse actually brought the girlfriend or boyfriend into the matrimonial home to stay with together while the other spouse is still there. So those are the examples whereby you can say, okay, I cannot reasonably be expected to live with my husband or wife anymore because of their actions. Another ground is if the spouse has deserted you for a continuous period of at least 2 years prior to the filing of the single petition. And lastly, if parties have lived apart for a continuous period of at least 2 years prior to the presentation of the petition. And some people have asked me, if I'm divorced, if I live together for 2 years, does that mean I automatically get a divorce? The answer to that is no, because it is not automatic. You have to actually apply to court and you have to go through the whole process before you can get a divorce. It's just that if you have lived separately for 2 years, then it is a ground to prove that your marriage has broken down. Okay. All right. Now we get to the nitty-gritty of it. What are the important things to consider when you are drafting your single petition? So, as mentioned by Carmen during the joint petition talk earlier, so there are actually 3 main things: the children, maintenance, and division of assets. So when we talk about children, what we talk about? We talk about custody of children. That is one of the main concerns. Who gets custody of a child? And there is a rebuttable presumption that it is for the good of the child under 7 years to be with his or her mother. Which means that if you have a child below 7 years old, the court will say, okay, maybe it's better for the child to follow mother. But since it's a rebuttable presumption, it means that the father can actually give evidence, give proof that actually this mother is not fit to be a mother. Maybe you can show that the mother always neglects the children, don't feed the children on time, or maybe she takes drugs, a drug addict. So these factors will tend to show that, okay, it's quite dangerous for the child to be with his mother. So then the court will say, okay, the presumption will be rebutted, and then maybe the custody will be given to the father. For other considerations is that the welfare of the child. So that is the paramount consideration. Number one consideration the court will look at is welfare of the child. Another consideration is if the child wishes of the child may be considered by the court. How this works is the court may sometimes interview a child privately without the attendance of the parents, and then will try to ask questions to get answer as to who the child wants to follow, so to speak. So, but only if the child can express an independent opinion, or if the child is mature enough. So the court will maybe ask questions like, okay, so why do you want to follow mommy? Okay. And if the child says, oh, because mommy always gives me a lot of toys, let me play games, no restrictions, then that is one way the child can answer. And another way is if the judge asks, why don't you want to follow your father? Why don't you want to stay with daddy? And then the child says, oh, because daddy always forces me to do homework like non-stop. He just wants me to study. Don't really let me play games. Don't let me eat McDonald's, for example. In that situation, then the court, it may appear to the judge that the thinking of these children are not that mature, because sometimes children may not know what is the best for them. And if they give these kind of answers, the court will think that the child is not mature enough to give their opinion. So then the wishes or views of the child as to who they want to follow may not be considered. Okay. Now, after the custody order is given, the access is usually given to the non-custodial parent, which means the parent who does not have custody. So, for example, if mother has custody, father will be given access. The type of access will depend on the case by case basis, but usually the court will allow a certain amount of access because they want the child to grow up with a whole family, so to speak. But there are sometimes where access are not given if it's shown to the court that the parent who does not have custody is very abusive. Basically, if the welfare of the child will be harmed, then access may be restricted or not given altogether. Okay, another thing you think about is maintenance. Okay, so child maintenance is to be paid until the child is 18 years old, or if child ceases to be under physical or mental disability, or if child ceases to pursue further education or training, whichever is later. Which in English, this means that if a child, normally if your child is 18 years old, then you don't have to pay maintenance anymore. But if your child wants to go study university or any further education, then you have to continue paying child maintenance. Or if your child has a physical or mental disability, then you also will still have to continue paying maintenance. Okay, so that's for children. Now for your spouse, in terms of maintenance, what do you have to give? So wives or ex-wives can apply for maintenance against their husband or ex-husband. On the other hand, husband or former husbands only can claim for maintenance if he is unable to earn a livelihood due to physical or mental injury or ill health. So this is actually, I think, quite old thinking, because last time I think husbands are the breadwinners, they go out to work, and then wives have to stay at home, tend to the house. That's why they have this kind of laws. But of course, nowadays we know that they are, of course, male and females will go and work equally. So, but this is still the present law at the moment. So what does the court think about when they want to decide how much maintenance you need to pay? One factor is they may say, okay, you need to maintain your wife to the same standard of living as she enjoyed during the marriage. So let me give you for example. If let's say you're a rich family, so you sponsor your wife's, let's say you give her a driver, you give her like a personal butler, you pay for spas, you pay for beauty treatments, you give her like, you pay for her travel maybe 3 times every year overseas. So those will be the standard of living the wife enjoyed during the marriage. So what happens after the divorce or during when the judge wants to determine how much maintenance to give is that they will try to make sure that your wife can still enjoy those things that she enjoyed during the marriage. Of course, this depends on whether the husband is actually still able to pay for those things. So this leads me to the second factor, which is the means and needs of parties. So if the husband is a person with means, which means he's capable of paying for those, then yes, probably he will need to continue paying for those. Another factor that the court will look at is degree of responsibility apportioned by the court to each party for the breakdown of marriage. So back to my example earlier, if actually it is the wife that caused the breakdown of the marriage, for example, wife committed adultery, then the maintenance payments might be reduced because the court says that actually you are the one that caused the breakdown of marriage. Conversely, if it's the husband that caused the breakdown, then maybe the maintenance amount will be maintained or maybe will be increased because it's the husband that caused the marriage to break down. Okay, now when does the maintenance payment end? So a right of any divorced person to receive maintenance will end on, number 1, his or her remarriage with another person. Number 2, his or her living in adultery with any other person. Number 3, if the maintenance is unsecured upon the death of either party. And number 4, if maintenance is secured upon the death of the party who's receiving the maintenance. So what do I mean by unsecured and secured maintenance? So for example, the court, when giving maintenance, will say, okay, maybe the husband has to give a $500,000 lump sum to the wife as maintenance. But the wife is worried that the husband will not give $500,000. So what happens is the court can order that, let's say there's another house, the court can say, okay, the husband have to hold this house on trust for the wife until the $500,000 is paid. So that is secured maintenance. So if there is a situation like that, then even if the husband dies, the wife can still receive maintenance because the maintenance is secured. But if it's a more common situation whereby, the court just say, okay, husband is to pay wife 3,000 ringgit a month, then there's likely to be unsecured maintenance. Then upon the death of either party, then the maintenance payment stops. Okay, now we go to assets, the third important item. So division of assets can only be ordered when a court grants a decree of divorce or judicial separation, which means that if you cannot, after divorce, go and tell the court, oh, sorry, judge, I forgot that we have this big bungalow in Johor that we actually want to split half-half. That you cannot do that because the court will not have the power, or at least the family court does not have the power to give further orders as to the division of assets after the decree of divorce is given. Okay, and some examples of assets that are usually divided is jewelry, houses, cars, bank accounts, money is in bank accounts, furniture, stocks, etc. So what kind of assets can be divided? So number one, assets acquired during the marriage. And if these assets are not acquired during the marriage, these assets are owned by one party before the marriage and is substantially improved during the marriage by the other party or by their joint efforts. So for example, if let's say the wife owned a house before the marriage and then got married, and then the husband came in, maybe he put in some money to include a new gazebo or something in the house, or maybe included like sun panels, solar panels or something, then the value of the house increases. Then that asset, that house, may be counted as the asset that can be divided during the marriage. So another misconception that people have is, only assets which are jointly owned by both parties, husband and wife, only you can go and try to claim for the other asset. But that's not the case. So assets which are also in sole names of the party, so you say that that house is only under my husband's name, can I claim for it? Yes, you still can. Whether you succeed or not is a different story, but you can still claim for it based on factors considered by the court. And the factors that are considered by the court are as such. So the court will look at your contributions, monetary and monetary, of each party towards the acquisition of assets. So look at who paid the down payments, who paid installments, those are monetary wise. So, but for non-monetary, and this leads to the second one also, extent of contributions by other party who did not acquire the assets to the wealth of the family. So if you're a house husband, you have a housewife, or even if you're working but you still take care, you're the one that takes care of the family, then the court will take those into consideration when deciding how they want to divide the assets. So it doesn't mean that your husband paid or your wife paid all the money to buy the house or the car, means he or she will get 100%. No, there are other factors that the court will still look at. Your contribution to the family. Other factors are debts owed by either party which were contracted for their joint benefit, needs of minor children, and lastly, the duration of marriage. So I've seen that for marriages that are longer, the court will usually try to give a 50-50 in terms of assets. But for marriages which are very short, maybe, 3 to 5 years, then the court will, that factor is less important. Because if longer marriage, and if the asset was acquired in the beginning of the marriage, then the court will see that, probably you actually bought the house or, for the duration of the marriage, so that to be used during the marriage. So then, if you're already 30 years, then maybe 50-50 is fair. Okay, lastly, some important tips to remember in terms of maintenance and division of assets. So remember, number one, to keep your receipts and bank statements. Because, like, for example, for maintenance, you will need to show your monthly expenses. Okay, if your toll payments, your car, petrol payments, your TV bills, electricity bills, all those kind of things, or your grocery spending. So you need to keep your receipts so that you can show that, to the court, I'm claiming for 3,000. How did I come to the amount of 3,000? Okay, you should also keep a bank statements. This is also for maintenance and also for division of assets, because let's say you paid this a monthly installment for a car, house, etc., then you will probably be in your bank statement and say that, okay, I've paid this amount. So it's easier for the court to see that how much you have paid, instead of you just saying, oh, I've paid half, 50% for the house, but where is your proof? So basically keep a record of your spending. And I mean, even in normal times, it's a prudent way to keep your financial health, because you need to know what you have spent on. And lastly, this is also important in terms of proving that you have to archive your WhatsApp, Facebook messages, photos, or video recordings if and when you have them. Because yes, this is not the most romantic thing to do, but if you're already contemplating filing for divorce, then having these messages, videos, photos backed up will be important, just in case your phone or your computer somehow doesn't get spoiled or doesn't work, or these messages get deleted by the other party, because sometimes you need this as evidence as well. Okay, so that comes to the end of my session. Remember, if you have any questions, please go on Slido and put in your questions, and the link is here and the QR code, and then Carmen and I will try to answer your questions accordingly. Okay, I will pass the floor back to our moderator, Prisilla, to handle the Q&A session. Thank you.
Thank you, Eric and Carmen, for the insightful session. We'll now move on to Q&A. Just a reminder here, you can scan our QR code and post your questions on Slido. Our code is 74388. 74388. Now, Eric and Carmen, we will move on to our Q&A session. There are quite a number of questions here. Let's start with the first one. Can I divorce my husband if we did not separate for 2 years?
I can take the question. Yep. So based on the 2-year requirement, right? There are certain exceptions to the 2-year requirement, which is based on the hardship suffered by the petitioner and also certain exceptional circumstances. So if you did not separate for 2 years, you can apply for a divorce under these exceptional circumstances.
Okay, can I add on that? So actually, if I think when I talked about the grounds for breakdown of marriage, so actually they are, besides what Carmen has said, they are also the usual circumstances if, let's say your marriage has broken down, your spouse have acted in a way that is not reasonable for you to continue living with her or him, or if there's adultery or desertion, then you can still divorce your husband, even if you did not separate for 2 years. So the separation is not the only requirement.
I see. So, Eric, can we now move on to the second question? Do I need to pay maintenance if my wife cheated on me? Okay, so yeah, again, during my talk, I did mention that the court will look at who caused the breakdown of the marriage. So yes, if you have shown that, if you can prove that really your wife cheated on you, then the court may give a reduced sum, or can even be zero. So it depends on the circumstances. But yes, it'll probably be less than if it's just a normal divorce and no one cheated on each other. I see. The next question is, would the child maintenance include higher education?
Yeah, I can take the question. So for this, if both parties has included a term for maintenance order for the higher education terms in the joint petition, you can include the child's higher education in the maintenance payment. Yeah, but do note that the maintenance payment will lapse when the child has obtained the age of 18.
Okay. Eric, do you have anything to add on that?
Yeah, so if it's a joint petition, you can actually include anything. So you want to include higher education, even after that also, if you want, if you're very generous, you can still give. But in normal circumstances, as in single petition, then yes, the child maintenance ends in when the child reaches 18 or when they finish their higher education.
Okay. The next question on the list is, my husband has left me 10 years ago. and I have no knowledge of where he is now, what is the most straightforward proceeding to initiate a divorce at lowest cost?
I'll take that. So one of I think straightforward proceeding is to go for single petition and say that your husband has deserted you. Then with that ground, you can ask for divorce.
I see. Eric, how long does this process take then? Since it's a single petition where the husband has deserted the wife.
Yeah, so this should be a lot faster because number one, you can apply to exempt from the marriage tribunal on the grounds of desertion. So that will cut the time from 3 to 5 months to maybe 1 month because you need to file application. You may want to file application for that. Then for single petition, I mentioned it was 9 months, but only is because if it is disputed, contested. So likely if you file a single petition and then your husband has left you, means there won't be a reply. Then probably another 2 to 3 months, then you can get your order. So I think the whole process is about 4 months from the filing to an order. And then your decree nisi can also be made absolute immediately because your husband left you. So there's no reason for you to maintain that 3 months cooling off period. So you can get it straight away.
Okay. I think that answers the question sufficiently. I'll now move on to the next question. Can I file a divorce petition within 2 years of our marriage?
Yeah, so as mentioned earlier, you can file a divorce petition within 2 years. So the 2-year requirement, there are exceptions as mentioned earlier. So if you can prove that you suffered hardship and other reasons, and the court will then exclude this 2-year requirement. Yeah.
Eric, you have anything to add on that?
No, that's pretty good.
Okay. The next question is, will I get 50% of my husband's assets if we divorce?
Yeah, let me answer that. So again, as I mentioned earlier, the court looks at a variety of factors as to how much percentage of your husband's asset when you get divorced. So it depends on your contributions and also depends on the length of your marriage. I think those are the bigger considerations. So yeah, it's hard to answer without knowing fully. But if you ask me whether it's possible, yes, it's possible.
I see. The next question here is, will we get the slides? I think I can answer this one. So you'll be getting the slides on our website later on, and this video will also be uploaded on YouTube. So you can check out our website and our YouTube channel. The next question is, how much do I need to pay for child maintenance and how to determine the rate?
Yep, I can take the question, Prisilla. So how much do I need to pay for child maintenance? So in joint petition, as mentioned in my slide, so it is an agreement or a terms that are agreed by both parties. So it's actually up to the both parties to decide how much do you need to pay for child maintenance, and the rate is also up to both parties. So if both parties agree and they put it in the joint petition, and you have to follow the terms in the joint petition. So it's up to parties to determine.
I see. That's for a joint petition. What about a single petition in terms of child maintenance?
Maybe Eric, you can address the part.
Yes, sure thing. So for child maintenance, somewhat similar to spousal maintenance as well. So you need to put in the court the monthly expenses per child. So you know what, maybe education, how much is spent on, let's say, piano lessons or swimming lessons, or clothing, books, etc. So those are the factors that you need to prove to court that, let's say you want to claim for 5,000, then your spouse will need to show, okay, or how much, why do I need to pay 5,000, for example.
Okay, thank you, Eric. The next question is, can I file a single divorce petition in Malaysia if my husband is a Singaporean, but our marriage was registered in Malaysia?
Okay, I can answer that. So, okay, I think just now Carmen did explain that you need to be domiciled in Malaysia before you can file a petition for divorce. Okay, and then they also said that if the husband is Singaporean and you are Malaysian, your domicile will likely follow the husband's. But there is an exception for wives to file divorce petition in Malaysia, even if your husband is Singaporean. So there are a few factors that the court will look at for you to file a single petition if you are a wife domiciled in Malaysia. So number one, your husband may have deserted you while he was still domiciled in Malaysia, and so he deserted you, or if he has been deported while he is still domiciled in Malaysia. So I think in your situation, it won't apply because your husband has been Singaporean all this while, and unless he has changed his domicile to Malaysia. So there is a last factor, which is if you are resident in Malaysia and you have been ordinarily resident in Malaysia for 2 years prior to filing the single petition. So actually, this is what we did for one of our clients as well. So the husband was a foreigner, not Singaporean, but another country. But the wife is Malaysian. And the marriage was registered in Malaysia. So what happened is we said, okay, the wife has been staying in Malaysia, resident in Malaysia, and has been staying in Malaysia for 2 years prior to the divorce petition. So under that exception, then we applied to court and we actually got the divorce order.
Okay, I think that answers the question. Carmen, you have anything to add?
No.
Okay, I'll move on to the next question. What happens if I have an order for divorce from another country? Is this recognized in Malaysia? Carmen, do you want to answer that?
I can answer that. So we have to look on whether the marriage is registered in Malaysia. So firstly, you have to check whether your marriage was registered in Malaysia. And if it is registered in Malaysia and you have obtained an order for divorce from another country, you can seek for the divorce order to be recognized in Malaysia. Yeah.
Okay, thank you, Carmen.
If maybe I just add a little bit to that.
Okay.
So Carmen's is correct. But there are circumstances whereby if let's say your marriage was not registered in Malaysia or not registered in a Malaysian embassy overseas. So what happens then? You can bring the divorce order to court and try to get it recognized. So you apply to court and say, okay, let's say I get divorced married and divorced in Japan, for example. Okay, so then you can apply to court to say, I want to recognize that divorce here. But the problem is your spouse will say that may want to say that actually no, the Malaysian court cannot do this because there's no connection of the marriage between Japan and Malaysia. So and then the Japanese laws are different. The Japanese marriage laws are different from Malaysia. So then that may affect the divorce or marriage being recognized here, or rather your divorce being recognized in Malaysia.
Okay, thank you, Eric. So moving on to the next question. Does the husband automatically always have to pay maintenance or child support to the wife? Or are there situations where the wife has to pay?
Okay, I think I'll say that because I also...
I think you mentioned in the slides earlier.
In my presentation. So there are situations where the wife has to pay, but only if the husband cannot, is suffering from physical or mental injury and cannot work. So important thing is you cannot work because of the injuries or ill health. Then the wife may have to pay. And in other circumstances, it is the husband will have to pay for spousal maintenance. But if for child maintenance, that's a different story. If let's say you have custody, the father's custody of the child, then a wife may have to pay maintenance for the child because now the father is taking care of the child on a daily basis.
Okay, thank you, Eric. The next question is, what happened if my wife refused to accept and acknowledge my divorce petition? Carmen, do you want to answer that?
For this, if both parties file a joint petition and your wife refused to accept and acknowledge, you may need to consider filing a single petition. Yeah, because joint petition is actually based on agreements of both parties. Yeah, so if she refused to accept, and you may consider filing a single petition. Eric, do you have anything to add?
Yeah, so if single petition, let's say you send it to your wife and they don't want to accept, then there are limitations as to when she can delay. So she cannot delay it for too long. So the court, if they don't receive a reply from the wife, can still try to proceed with the divorce petition.
Okay, thank you. The next question is, if I'm unemployed or I've lost my job, do I still have to pay for my wife's maintenance if she has a job?
Okay, shall I answer this? All right.
Sure.
If I'm unemployed, I lost my job, I still have to pay for my wife's maintenance. Okay. So the court looks at the means and needs of a party. So in terms of means, let's say if you are unemployed and you have lost your job, means you may have less financial capabilities. Then yes, the court may say that you don't have to pay, or maybe a very small amount, because the court wouldn't want you to be bankrupt in the process of having to pay for your wife's maintenance.
The next question is, what's the difference between divorce and judicial separation?
Yep, so I can take the question. So a difference between divorce and judicial separation, actually judicial separation means that the marriage is still subsisting, and for judicial separation, there's no 2-year requirement for parties. And once a judicial separation order you have obtained a judicial separation order, you are legally separate with one another, but you are not legally divorced. And you cannot be married until a decree of divorce has been obtained. Yeah.
Thank you, Carmen. There is a question that has been upvoted. When the ex-spouse is having a girlfriend, does that mean he is living in adultery? How to determine? Eric, do you want to address that?
Yes, how do you determine if the person is living in adultery? So, for example, if you have evidence, you have pictures, video recordings of them actually staying together already, okay? Staying together, and the best example is if she has a baby by the other half, the boyfriend, then that goes to show that that he or she is living in adultery already. So then I guess it's in terms of the maintenance question lah.
Okay, thank you, Eric. As we are now running short of time, I will take the next 2 questions before we end our session today. Is that okay with Eric and Carmen? The next question is, if a house is jointly owned by husband and wife in equal shares, will the wife get the half of the value even though the husband paid for all the installments?
Yeah, I can answer this. So if the house is jointly owned by both parties in equal shares, even though the husband has paid the installments, court will also look into the non-financial contribution of the wife in the matrimonial home. Yeah, so it will usually be in equal shares, and the wife can actually seek half of the value.
Okay. Eric, anything to add?
Yeah, I mean, that's correct. So, I mean, the most important is contributions lah. So it doesn't matter financial or non-financial.
Okay, thank you. For our last question, can a single petition later be converted to a joint petition?
Okay, let me close that off with the answer. A single petition, well, strictly speaking, you don't convert it to a joint petition. What parties do in practice is you come to a consent order as to what terms you want to apply. So somewhat like a joint petition, but it's just a name as consent order.
Okay, I see, Eric. Thank you. With that, we end today's Q&A session. Thank you, Eric and Carmen.
Thank you very much, everyone, for coming.
Before I conclude today's session, I have a few announcements. Please join us for our upcoming talks. The next one is on 18th of May 2020. Our topic will be on Introduction to Management and Maintenance of Strata Developments by our Senior Associate John Chan and our colleague Celine Tay. You can sign up to the talk by scanning the QR code on the slide here, or you can go to our website, www.mawingkwa.com, talks, sign up. Next, we will appreciate if you can follow us on our social media accounts. You can replay our videos on YouTube, Twitter, Instagram, LinkedIn, and Facebook. You can also sign up for our online talks by scanning the QR code here again. If you would like to have legal consultation, we offer a 30-minute video or telephone consultation with all lawyers. You can simply fill out the form by scanning our QR code or go to our website. With that, our session today has come to an end.